morning. Please be seated. Chopping, would you like to come forward, please? Chopping, could you just remain standing? Would you like to take an oath or an affirmation?
Affirmation, please.
Right. Please state your full name.
Lainey Marie Chopping.
And could you please take the card with the affirmation on it and read it out aloud?
So I, Lainey Marie Chopping, sincerely declare and affirm that the evidence that I give to this commission shall be the truth, the whole truth, and nothing but the truth.
Thank you, Ms. Chopping. Please take your seat and make yourself comfortable. Yes, Ms. Seawood.
Please, the Commission. Ms Chopping, you are the current Director-General of the Department of Local Government, Sport and Cultural Industries.
Yes.
And you've received a witness summons to appear at this Royal Commission.
Yes.
And attached to that summons or accompanying it was a list of questions and you made a statement.
Yes.
In relation to those questions. Now in front of you should have a copy of a document. If I could ask you to have a look, please. Is that a copy of your witness statement that you prepared dated the 31st of August?
Yes.
And on the back page we can see you have signed it.
Yes.
And if you turn back one page, it's a total of 74 paragraphs. Back 2 pages, perhaps.
Yes.
Were there any errors you noted when you were reviewing this morning?
No.
Thank you. And is the contents of this witness statement true and correct to the best of your information, knowledge and belief?
Yes.
May it please the Commission, I tender Ms Chopping's witness statement, which is number DLG.0001.009.027.
The statement of Ms Chopping carrying that number will be an exhibit in the Commission. Thank you, Ms Seawood. Yes, Mr Lee.
Thank you, Commissioner. Ms Chopping, I'm one of the councillors assisting the Commission. The first question for you is in relation to, paragraph 4 of your witness statement, where you explain that on 31 May 2021, you were directed to act in the position of Director-General of the Department of Local Government, Sport and Cultural Industries. And for the remainder of this hearing, I'll generally refer to that as the Department, just for ease of reference. You explain you were directed to act at that date, and your ordinary substantive position is with the Department of Mines, Industry Regulation and Safety. Is that correct?
Yes.
So is it right to say that the position of DG for you at the moment is only an acting position?
It's a interim position, so the appointment is for at a period of 6 months, and then the position, there's a range of Director General positions that have been filled at that time through various rotation or acting interim placements, and then those positions that are vacant due to retirement of the previous Director General will be advertised in due course. One of them has already been advertised. This position is yet to be advertised. But yes, I am the interim Director General of the department.
And you explained to us just there that for the moment that's a 6-month appointment, but as yet no advertising for a permanent position. So is it possible that that might extend to a further 6 months or longer?
I don't have any information about what happens next. All I know is that my direction to act is for a period of 6 months.
You also explain in your witness statement at paragraph 10 that although you've got very extensive experience as a public servant and a regulator, you don't have any experience in relation to casino, gaming or racing and wagering. Is that correct?
That's correct.
And you then explain that you've taken some steps to initiate membership of the International Association of Gaming Regulators. Can you just explain to the Commission membership for who? Is that for the department or the GWC?
So my staff are currently exploring the different versions of membership that could be created with the International Association. I was surprised that we weren't already a member, so I've asked them to explore what our membership history has been with the both for GWC and for the department, and for individuals or as organisational members. So that's yet to be resolved.
When you say you were surprised to find out that you weren't already a member, is it your knowledge or understanding that other regulators around Australia are members?
Some other regulators are members.
You mentioned that the membership will allow access to professional development for you and relevant team members. Who do you encompass in that description of relevant team members?
So it's my strong view that all of the staff who work on gaming-related matters require capability development. That's definitely part of our forward work program. Understanding my needs for development, the GWC board members' needs for development, and then cascading downwards, right down to the person who answers the telephone in terms of each of their capability requirements for further professional development is part of the work that is being undertaken at the moment in the organisation.
So in that answer you mentioned GWC board members.
Yes.
Does that mean that you're considering or intending that those persons would also get training through this organisation if it's available?
Definitely. So when I first met with the GWC board members at my very first meeting, I indicated to them that I felt that intensive training in relation to regulation would be beneficial for all members, and a number of the members indicated that they would like to take that opportunity, and that is definitely part of our forward work program. Whether some people would benefit from, such as myself, would benefit from greater technical understanding of casino regulation in particular, or gaming and racing regulation. Other people may benefit from more regulatory theory and practice capability approach type training. So it will really be a need to assess, and for individuals to assess their own needs, and then for an assessment to be undertaken more broadly of what the needs are in the department and across the GWC board.
One of the other things that you mentioned in relation to training is at paragraph 20 of your statement, where you say that you've received a presentation from the SSO helping explain the legislative framework, and you mentioned that you would encourage other people to take advantage of that. Are you aware of whether any persons at the GWC have yet taken advantage of that program or training?
I do not believe that since I've been in the role, I have made that offer available to people for people to have further training in relation to the legislative foundation, the purpose of each of the pieces of legislation that the GWC is responsible for. That has yet to be accepted, but the GWC members have prioritised some of the other needs that they've had around their strategic planning, for example. So I've no doubt that in due course, when those training programs are offered, that they will be accepted by people. But I have indicated to people that training would have been available on the day of the strategic planning day. Members felt that they wanted to take a different approach on that day, and that was very early in my term. But definitely I asked the State Solicitor to put together training. Well, first I asked General Counsel within the department to put together some training, but it was clear that General Counsel had not provided that kind of training for induction for gaming-related matters previously. I then asked her to attend with me the training session with SSO to get a foundation understanding of the legislative context.
Shifting gears for a moment, at paragraph 18 of your witness statement, you explain that you don't think that the chairperson of the GWC and the DG of the department should be the same person because it would create potential conflicts of interest in that role. Am I correct in what I read in paragraph 17 and 18 that you don't consider that such a conflict has yet arisen for you in your discharge of those roles?
I think it's a suboptimal arrangement to have a Director General of a very large department also holding the role of chairperson of a statutory authority, just simply in terms of the workload that's required. And Duncan Ord has, I understand, given evidence to that effect previously with the Commission. So it's suboptimal in terms of just the amount of hours that are available in the day to dedicate. I've worked in statutory authorities with regulatory functions where there's been a full-time chairperson and a full-time CEO. So I can see the benefit of that kind of model of having a full-time remunerated chairperson separate to the Director General. More specifically, obviously, it comes up in relation to issues, for example, where it's an odd scenario to be in, where the part of the department is delivering compliance and audit function, for example, and I'm representing both the departmental head as the accountable authority for the department, as well as the chair role. Today, I haven't had a conflict because I'm very clear with people about what the expectation is for their improvement or the change in the way that the functions are achieved, and that is simpatico, I believe, with the GWC board members' expectations.
So one of the things you talked about there was the challenge of having a finite number of hours in the day and how that can impact upon a person who's carrying out two roles. Do you think the same difficulty can arise in relation to other persons who are carrying out two roles? And here I'm specifically thinking about a person carrying out the function of the chief casino officer while simultaneously being the executive director, racing, gaming and liquor. Do you think those same tensions can arise in terms of resourcing and prioritising in that role as well?
So it's very soon in my tenure to be making bold statements about what I would want to see as a platinum standard in terms of structure, function, and how the department would discharge its responsibilities that it has to the GWC. I would never say no to additional resources that would create a separation between a person dedicated to deal with the statutory delegated functions and a person to deal with the executive management functions. Is a step in the right direction, which is one of the reasons that I appointed an executive manager at a senior level, an experienced person to come and provide some executive functioning between the GWC and the department. So, it's hard for me to say yet exactly what the optimal model would be, but more resources and a greater ability to focus purely on the statutory function versus the executive function, I think would be a step in the right direction for the Director General role.
Okay, so that answer there went into some detail about, as you said, statutory function versus executive function. I have a similar question, but this time in relation to people carrying two departmental roles. This commission heard some evidence yesterday from Ms. Shedewala in relation to the Chief Finance Officer role. And as I understand that evidence, and I only listened to bits of it, there were instances where she explained to the Commission that on occasion she would issue an invoice in her capacity as Chief Financial Officer for the department and then subsequently approve or deal with that invoice herself again as Chief Financial Officer for the GWC. So that kind of arrangement where a person is essentially having to deal with themselves as a finance officer in both sides of the ledger, is that something which also in your view might be suboptimal or create tensions?
So I believe that the information's been provided to the Commission through accompanying documents. The interim structure that I have put in place in consultation with the Public Sector Commission within the department makes a series of changes in terms of the roles within the department and responsibilities. Importantly there is a new Deputy Director General who oversights a range of, there's two new Deputy Director Generals. One oversights the functions of finance and procurement and a range of other corporate services type functions. He comes in with financial acumen, experience in the past working for Treasury, most recently working for one of the government trading enterprises, the Water Corporation. So he started 2 weeks ago, I believe. He's able to provide further oversight of our finance and procurement area, but importantly look at what our needs are going forward there for both systems, processes, roles and responsibilities. So he's started, and also I have organised for a placement from Treasury who I believe has commenced. So a senior officer from Treasury to assist us with reviewing some of the ways that we work. Also along the lines of also in relation to the interim structure, we sitting under the Deputy Director General Portfolio Coordination is a new role titled Executive Director Strategy, Accountability and Performance. And that person started on Monday. That person's name is Robin Ho, who's come to us from the Department of Premier and Cabinet. Part of her work will be to, I gave her priorities on Monday. Those priorities included the need for us to have a very clear understanding of roles, responsibilities, governance, service level agreements, reporting requirements, accountability requirements that exist between ourselves and statutory authorities and boards across the broad agency the broad department. I see that as being a really strong step in the right direction in terms of making sure that everybody is absolutely crystal clear about roles, responsibilities and governance arrangements in terms of how things should be functioning in relation to such things as the financial accountability that exists between the department and GWC.
Thank you, Ms Chopping. The next question I wanted to take you to is something you deal with paragraphs 19 to 24 of your witness statement, which is the powers, duties and obligations of the GWC. Paragraph 22, sub A, sub 1, you comment that you don't consider that there's been pre-existing policies of the GWC that display a consistent theme or objective. And then at paragraph 23, you say that one of your most urgent priorities, both as Chairperson and Director General, is to clarify those regulatory objectives and philosophies across the GWC and the department. Am I right in understanding from those paragraphs that your intention is to carry out a wide-ranging and fundamental review of the entirety of what is done by the GWC and the department, which I think fits in with your earlier answer as well?
Yes, definitely. And that work has already commenced. So bringing in a dedicated executive director of racing, gaming and liquor who has, whilst she doesn't yet have, as the same as I, does not yet have the technical detail in the gambling space, that can be learned. What she does have, importantly, is that she is the most, I believe, qualified person within the public service in terms of regulatory reform and regulatory capability development. She is widely respected amongst her colleagues and was recommended, I already knew her, she was recommended to me as being the best placed person by a number of people who I respect who work in regulation across Western Australia. She has immediately hit the ground on the basis that she needs to understand the current framework and understand how we are as GWC discharging that framework and how the department is operating to ensure that framework is operating effectively and what changes would need to be made. And that starts with having a crystal clarity across everyone about what is the purpose of what's the legislative purpose outlined to the GWC, and then is the current way that legislative purpose being met, is that the best way for it to be met? What is the optimal way? Now, both Jermaine Larkham and myself and others who have commenced with the agency, and indeed people who already work in the department, and indeed as I understand it from my GWC colleagues, would agree that the current way that it's being done is not the best way that it could be done. And we're definitely started on a journey to make it the gold standard in terms of gaming and racing regulation in Western Australia.
Now, this might not be something that you can answer at this stage because it might be a work in progress, but you've mentioned purpose on a few occasions in that answer. Are you able to articulate what you currently understand to be the purpose of the GWC?
Yeah, so my understanding from the legislation is that the purpose of the GWC is to regulate the gaming and wagering system in Western Australia, including the casino. And in doing so, it needs to keep an overview and an understanding of what is occurring within the market, to report on any issues of concern to the Minister in relation to the operation of gaming, wagering, casino in Western Australia, to undertake recommendations to the Minister around his approval requirements under the legislation, to ensure that the licensing functions that are conveyed upon GWC to license certain operators or participants within the market are done efficiently and effectively. And to importantly ensure that it understands the role of gambling within the community, the broader community, and that it understands gambling harm and harm minimisation, and how that is to be addressed.
I'll come back to the issues
Yep.
of harm and minimisation a bit later on.
Okay.
At the moment, do you have a sense of how long this reform agenda is going to take to implement, or is it not possible to say at this point?
So I believe that we've already achieved a significant start in relation to a range of issues that need to be remediated. Those issues include the issues that were outlined in the interim report from the Royal Commission, the issues that have been raised through internal review, internal audit, and the issues that are apparent upon arrival within the department. So we're really in a remediation phase at the moment and a restocking phase. So there has been a period of significant disruption to the organisation, obviously with the Director General leaving, retiring, with the Deputy Director General Regulation, who was also the CCO, commencing long-term, being removed from involvement in racing and gaming matters, and then commencing a long period of leave. Under that person were also other people who carried significant corporate knowledge, who have now gone on long-term leave. The immediate priority for us is to ensure that we address the risk associated with the loss of corporate knowledge. So remediation around that has meant that we've brought in additional staff on loan from the Department of Premier and Cabinet to document. So to basically construct, where they don't exist, records of the ways of working within the organisation, policies and procedures, other important information that exists mainly within the people who've actually been doing those jobs. So we're in a remediation phase. We then move into a planning phase. So we've done strategic planning as a GWC. We've commenced that work. There is now approved last Friday at the August meeting was the results of that strategic plan. The executive manager is now progressing that into a project plan with proposals for priority work and costings associated with that work, with a view to that being presented at the September 21 meeting for the GWC to identify the priorities and then confirm which matters will be taken forward in terms of implementation. Now, I can't say when, because I'm not sure exactly what the GWC will prioritise, and obviously the costings associated with that work. I'm not sure when the implementation will occur. But what I can say, hand on heart, is that the organisation is significantly progressed in the 12 weeks that I've been there, and you can tell the difference from the remediation already.
All right, so September obviously shaping up to be a bit of a significant milestone then in terms of assessing where to next from the GWC's perspective. From a
GWC perspective,
yes.
They will be presented with our assessment of the work that they did in strategic planning, but also importantly the work that we've done internally and what we think needs to be done as well, because the people who work internally and have come in internally have a particular understanding of some of the things that need to be done within the organisation, and that needs to be communicated clearly to the GWC as part of any consideration about what priorities are going forward.
So you've detailed a significant amount of information in your answer there about the work that the department is doing, documentation of that work with the GWC. One of the things you haven't yet mentioned is in terms of perhaps the relationship between the regulator and the casino. Now that's something you touch on at paragraph 22B of your statement, where you say that you formed the view that there had been, quote, a large amount of trust and confidence placed in the licensee in the past. It may be too early for you to answer this question now, but are you able to comment as to whether you have a preliminary view as to whether that level of trust was excessive?
Yes, I think that level of trust was excessive.
And do you consider that perhaps the attitude or the approach from the regulator to the casino is evolving and changing, and if so, how?
I definitely think that there's exposure in relation to some of the shortcomings of the department. There's definitely some exposure on some of the shortcomings of the GWC. I think in having that exposure and then having fresh eyes asking questions, there are some moments of realisation that within the GWC board members and within the departmental staff that they were perhaps not as suspicious as they should have been in relation to the information, both for GWC members in terms of the information that was put to them by the regulated entity or indeed by the staff within the department. There is definitely a healthy level now, I believe, of discussion going on in relation to issues, for example, of independent verification. So I personally have been very strong in asking departmental staff to provide, when providing papers, to provide a range of additional information that wasn't apparent in papers previously, and to attest to the veracity of the independent verification or otherwise of assessments that are being undertaken in relation to information provided by the regulator.
In a moment, I'm going to ask you to give an indication, perhaps at a high level, as to what you consider to be an appropriate regulatory posture for a regulator like the GWC to adopt in respect of a statutory monopoly enterprise like the Perth Casino. But while you think about that issue, that question, I want to draw your attention to what was said by Mr. Duncan Ord, the previous Director General, in his first witness statement to this Commission. Mr. Ord said of the GWC's purpose, specifically of protecting the public interest and being a model regulator that uses powers with a presumption in favour of education and improvement over punishment. And for the transcript, this is DLG.001.002.001 at 49D. So my question to you is, thinking about the posture to be adopted by a regulator, do you agree with that approach, that a regulator should be one with a presumption against punishment?
No.
What is your view as to what is an appropriate posture for a regulator to adopt?
I think a regulator needs to understand the regulated entity, understand the market in which the regulated entity operates, and understand the harms that may eventuate through within that market. So they need to have a very deep and clear understanding of harms. From there, they then need to understand which harms they are going to focus on addressing and how they might go about addressing those harms. Well, firstly, they need to understand the prevalence of the harms and then understand how they will address the harms. In addressing the harms, the ability to be able to address the harms will depend on a range of factors, including the nature of the regulated entity. And if the regulated entity shows a propensity towards compliance and is able to be independently assessed as compliant without the need for enforcement at the higher order in terms of disciplinary action or licence suspension or any of the higher order kind of interventions, if they're able to be independently verified as compliant through education and through corrective action or through any number of other intervention tools, then so be it. But it shouldn't be that the approach should be always softly, particularly if softly isn't resulting in what you what your regulatory purpose is. Now, it's too soon for me to tell whether or not the regulatory purpose has or hasn't been achieved in relation to all of the responsibilities of the GWC. Some, it appears that it may not be the case, but it's too soon for me to tell that in any fulsome way. But definitely, you know, I'm a very strong subscriber to the idea that you use all the tools available to you as a regulator to achieve compliance, but that having a deep understanding of the market, the harms, and the regulated entity is the best starting point for that.
All right, thank you, Ms. Chopping. One of the other things that you note in paragraph 22D of your statement is that the GWC doesn't, to your present understanding, appear to have had any pre-existing policies in respect of junkets, money laundering and criminal infiltration of the casino, consistent with the view that was then held that came within the remit of other regulators. What's your view today as to whether or not those matters come within the remit of the GWC?
I think there's a significant amount of work to be done with the other regulatory agencies responsible for example, anti-money laundering identification, and that's definitely on our work program. My current view is that there's a co-regulatory responsibility for money laundering, and that it's not uncommon for regulators to want to have a very strict understanding of what is their responsibility and what is someone else's responsibility, because regulatory work is complex work, and staying in your lane is often the case. But in my experience, the best way for us to discharge our responsibilities as regulators is to work firmly hand in glove with our co-regulators in any space. And in my background, that's been very much the case in situations such as product safety, fraud. All of those kinds of areas have always had co-regulatory responsibilities that are clearly outlined, and a intention is expressed and understood around information sharing and around who's going to do what to who.
And to put it in short summary, if it's co-regulation, no, that's all right. But if it's co-regulation, then that obviously means others may have a part to play too, but the GWC has a role to play in each of those areas.
I believe that the GWC has a role to play in relation to that area, those areas. I have sought advice from the State Solicitor.
Don't let us know the content of that
Okay,
advice.
no, I'm not going to. In relation to how we might best go about discharging our responsibilities.
Okay. You do mention in your witness statement some information about anti-money laundering and some audit programs that are going on in relation to that, and we'll come to that a little bit later. But I just want to ask in relation to junkets and casino infiltration by criminal elements, are those matters where you consider that there might be scope as well for the department and the GWC to be developing audit programs? And likewise, and you're nodding to that answer.
Sorry.
Likewise, in relation to responsible service of gaming or harm minimisation, are those things that also could be provided with an audit program?
Yes.
Moving away from those series of questions, I'd now want to take you to paragraph 24B of your statement, where you explain that you have tasked Ms Larkham, who's now the ED-RGL, to separate officers so that they work solely on liquor on the one hand or racing and gaming on the other. My question is, does that include inspectors, such that there might now be people who are carrying out inspection functions solely as casino inspectors, or is that something different?
That does include inspectors. So part of my request to Germaine has been to separate racing and gaming from liquor, and then to hygienically seal the casino functions within the racing and gaming area, so that we can focus those people on exactly the tasks that need to be completed. In my experience, and I'm not saying this is what has happened here, but in my experience that there is a tendency amongst inspectors to sometimes gravitate towards inspections that are less onerous. And so being able to make sure that you've got a robust, supervised audit program that's well thought out and approved by the Gaming and Wagering Commission, that the best way to do that is to have small numbers of skilled people who you are able to develop. You can have appropriate systems and processes in place, and that there's no necessity for those people to be liquor inspectors.
Thank you, Ms Chopping. Now, I can bring it up if you'd like me to put it on the screen so you can review, but I have in mind one of the documents that you provided to us as part of your witness statement, which is the draft response to the Auditor General's report, where they had looked at the tax verification that was being carried out by departmental officers. So I can put it on the screen if you want, but the only point I wanted to draw to your attention is that there's a comment in that draft response which says, the review recommends the reintroduction of a dedicated inspection presence at the casino. So does that mean that the department is also thinking about making it 24-hour-a-day supervision at the casino?
So I think previously I indicated that we're looking at our regulatory function from end to end, and nothing is out of the question in terms of what we would propose to the GWC in terms of what would be a way forward in terms of what would achieve the best practice for them. But it's way too soon to say whether or not that would actually be a proposal, or indeed whether or not it would be the one that GWC decides to go with. But yes, we are considering all options in terms of the way in which the casino is regulated.
And you said before you think it's a good idea to have small numbers of skilled inspectors carrying out particular tasks. Has there been any decision made, or is it still in the process of being decided, how many inspectors will be that small number at the casino?
So I have started familiarising myself with the historical information in relation to the Department of Racing, Gaming and Liquor, and the numbers that existed some time ago and the numbers that exist now. And I'd be highly surprised if our review of the regulatory arrangement for the casino didn't include additional staff. Whether that includes additional inspectors employed in the same way that they're currently employed, it's too soon to tell.
Moving on then to what you talk about at paragraph 24C of your statement in relation to a costing model, which you've developed, or rather you've directed that officers develop for the purposes of the GWC. And I just want to understand the parameters that will be involved in this costing model. Is it your intention to try and ascertain the actual time spent by persons doing GWC work, and then work out the actual salary costs of those persons plus actual overhead costs, rather than doing an aggregated cost and then dividing by areas?
Yes.
Thank you. And is that the same point that you pick up generally at paragraphs 57 and 60 of your witness statement, where you talk about wanting to see the development of a service level agreement, setting out the terms and expectations by which the department provides services to the GWC and seeks cost recovery for those services?
Yes.
And so that will ultimately be a written agreement in accordance with what's contemplated by Section 18 of the GWC Act. I can bring that up if you'd like to see that that provision.
It will be a written agreement, and it will ensure compliance with the legislation. Yes.
Thank you. Just one last question on this area. You mentioned earlier that there was a new person. I'm not sure if you said it was a executive manager or a general manager that's now been allocated to the GWC. Is that person Ms Sophie O'Keefe?
Yes.
And can you explain in a little more detail for the benefit of the commissioners what is contemplated to be entailed in Ms O'Keefe's position?
So when I first arrived, what struck me as unusual was that some of the issues that had emerged appeared to be because there was a lack of clear governance arrangements between the GWC and the department who were delivering services on behalf of the GWC. So I asked the question as to who's responsible for the governance, the roles and responsibility, the planning, the how GWC functions, their strategic plan, their annual report, etc. And I wasn't able to find a clear answer. I was given a mixture of answers between, we sort of share the work around within the strategic regulation area or within the regulatory division that the previous Deputy Director General operated. So clearly, from my very first meeting with the GWC members, clearly there were screaming issues in terms of a lack of understanding around governance issues, roles and responsibilities, induction, the basics. And a lot of the things that they came up with at their strategic planning day, the GWC members, are the kinds of things that you would expect to see, you know, in a well-functioning governance arrangement. So Sophie's been appointed to undertake those kinds of, to deliver those kinds of things, to ensure that that they have a strategic plan, that the strategic plan is actually on point and addresses the things that they need to address, that then there is an actual implementation plan for that, and that there's appropriate governance systems operating. That will include things like improvements in the agenda packs that are provided to GWC members in terms of quality, timeliness, context, the way that papers are put together, and other enhancements. So GWC members would like to see a digitisation through software package so that they're able to access information in a better, more modern way. So Sophie will be responsible for some of the project work that goes around making GWC function more effectively.
And it's envisioned at this stage that Sophie will be doing, as you say, a lot of project work. Once those projects are completed, is it envisioned that she will remain on, or it's uncertain at this stage?
So I'm here for 6 months, and the people, so the Deputy Director Generals are appointed for 6 months. The structure is an interim structure that's subject to approval from the Public Sector Commissioner. If I'm here and the Deputy Director Generals are here, then myself as the employing authority of Sophie's position will be I can't imagine a circumstance where where that position would not be made a permanent role. Whether Sophie will be doing the job or not, however, will depend on recruitment arrangements. She's there for 6 months at this point. On to comment.
Thank you. Moving now to another matter, which is quite a discrete question, and that's in relation to an MOU that is currently in existence with the Department and the Department of Communities.
Yes.
And you mentioned in your witness statement that MOU has essentially expired at the moment, and the PCRC has been provided with a proposed MOU from Department of Communities, which is proposing additional funding of $500,000 for the next 3 years. You said, I think it's paragraph 29 of your statement, that you're yet to consider the MOU. Is there any reason that hasn't yet been considered?
It hasn't been, to the best of my knowledge, it hadn't been submitted to me when the statement was being prepared. Whether or not it is in my office of the Director General awaiting my consideration, it likely is, because it's now been the subject of this, but I don't know why it hadn't come to me yet. I can't answer that.
All right, and I might be putting you on the spot, you may have to reflect upon this, but if it is waiting for you back at your office when you return, do you have a present view as to whether that MOU will be extended, or is that something yet to be decided?
So that will need to be the MOU for financial counselling services, I believe, should be extended. The Problem Gambling Support Services Committee, I think is working on a range of things, including its terms of reference and consolidation of membership. So Erin Gauntlet, the other Deputy Director General within the department, and also the ministerially appointed Deputy Chair of the GWC, has been appointed as the new chair of that subcommittee. And part of their work is to obviously do the terms of reference and do planning work, but also to commission research in relation to gambling harm. And part of that will look at the issue of the ongoing funding in relation to financial counselling. Having reviewed the content of the program, I'm familiar with financial counselling because I have worked in community legal centres that operate financial counselling services, and I was surprised to find that the ratio of people reporting problem gambling was 0.8%, which surprised me because I, in my experience, would have thought that that number would have been higher. So I can't see any reason why financial counselling support wouldn't continue.
Thank you, Ms. Chopping. The other question that I had, which we may not need to go into in any detail based on what your earlier answer was in relation to Mr. Connolly, and you mentioned previously that Mr. Connolly is no longer working in the racing, gaming, liquor area, and I think you mentioned this as well at paragraph 41 of your witness statement. You say he's been transferred to a new position and will not be returning.
Sorry, Mr. Lee, just wait. Mr. Malone.
Yes, sorry, Commissioners. That paragraph is now subject to an application for non-publication that's been made this morning.
Right.
Just in relation to public screens, that's all.
Just in relation to?
Just in relation to it being shown on the public screens.
Well, that's fine. Was it paragraph 41? Yes.
Yes, Commissioner.
So, for the time being, can paragraph 41 not be shown on the public screens? Thank you.
So I don't need to go into this line of questioning depending on what your answer to my next question is. Do I understand what you say at that paragraph to mean that Mr. Connolly's transfer is permanent and that he will not, while you are the DG, be transferring back to racing, gaming and liquor?
Whilst I am the Director General, he will not be working in racing, gaming and liquor upon his return. If he does indeed return from leave to the department, he will not be working in racing, gaming and liquor.
All right. In that case, I can move to some different questions in relation to the capabilities of GWC members and the CCO. So at paragraph 46 to 48 of your witness statement, you deal with the appointment of the Chief Casino Officer or the CCO. And you don't expressly say so in your witness statement, but is it your understanding that the appointment of that person is a responsibility that falls to you as DG?
So yes, it is. Because the person is appointed under the Public Sector Management Act and yes, and I employ the person, that I understand that that is the case.
And I guess as a corollary of that understanding, it's your view that that's not a role for the GWC to perform, to appoint that person?
Not at this stage, but I also, not at this stage.
All right, and without going into the content of any advice you may have received, is that a subject in respect of which you have received advice, the proper person for the appointment of the CCO?
The proper process for the appointment of the CCO?
Which person should be the person that does appoint the CCO, whether it should be you as Director General or alternatively the GWC as an entity? I have received preliminary advice. I won't take it any further.
Okay.
I was just curious as to whether that's a matter that's being considered.
Yeah.
The next question then is in relation to the appointment of Ms Larkin. Did the GWC members have any input into her appointment before that selection was made?
So I provided the GWC with a presentation on my intentions and the approved interim structure that I had developed in consultation with the Public Sector Commission. That included the establishment of a unique new position as the Executive Director, Racing, Gaming and Liquor, and the full Senior Executive Service contingent of the new structure, which meant that the temporary Level 9 position that held the CCO delegation came to an end on the 30th of June. The question then was, for me, was where would the CCO role best fit after this new structure had been put into place?
I might not be making myself clear in terms of my question. What I'm really asking
Yes.
is in terms of the identity of the person. Did you seek the views of the GWC?
No.
Did you let them know beforehand who it was going to be in case they could comment?
I said to them that I would be looking for the person who would be best placed to be the ED of racing, gaming and liquor under the current circumstances that we found ourselves in, and that I would do my best to get someone that would be able to have a focus in relation to the areas that were being identified as problems. But no, I didn't ask them to review. They are not the employing authority for the ED racing, gaming and liquor, so I didn't ask them to review any content prior to the appointment.
You would accept that it's of critical importance to ensure that there's a good working relationship between the GWC and the CCO,
Yes.
and that this is even more likely to be the case in the future if the GWC takes a stronger stance on oversight of the CCO. And I think you flagged that at paragraph 61 and 62 of your witness statement. You suggest that there hadn't been very much oversight in the past, and if I read your statement correctly, suggest that there might be stronger oversight in the future.
When I say oversight, I'm not referring to supervisee type relationship. That's not what I'm referring to. I think there is a good. So can you ask the question again?
What I'm really driving at is to ask, in circumstances where the GWC is highly dependent on the CCO, they have a very close working relationship, do you think it might be better, as an ideal practice, for the GWC to have input as to which person will be the CCO, or at the very least to have the proposed CCO told to the GWC so they can raise any concerns they might have as that person being appointed?
So I hadn't considered that, but I would be open to that, and I'd be open to discussing that with GWC and with the Public Sector Commissioner and with the Deputy Director General who's responsible for the employment. You know, it would be is the supervisor of the person who holds that position in the organisation.
Well, in that case, I can move on to ask you in some more detail about what you discuss at paragraph 51 of your witness statement, which is the anti-money laundering audit proposal. And if I read it correctly, the plan is that each year an AML expert will be appointed. That person will go through and audit the bank accounts from the casino. They'll confirm that the casino manual properly reflects the AML program that the casino has, and then they will produce an audit program which inspectors will then audit for the forthcoming year. Is that correct?
I have asked for, very early on upon my arrival, for quotations to be sought on the engagement of external experts to review the current AML and CTF arrangements in place, to then understand the information that's been provided by the regulated entity and to provide advice on the compliance state, and the degree to which a design of the audit program, how far that would go in terms of whether that would design an audit program for our current inspectors to inspect versus a different form of audit that might exist in the future. I don't. So that last part, I think, would need some further work. There'll definitely be an audit program that will be recommended as part of that work, but whether or not it ends up being that the inspectors themselves are doing that work or whether there's some other way that gets achieved, I couldn't confirm that at this point. It's under development. The costings associated with doing that need to come back to GWC as part of the prioritisation of what they need to, what we as GWC need to authorise as work to be done by the department to meet our regulatory purpose in the best possible way.
And your point there about costings leads me into the next thing I wanted to ask, which was in terms of whether there's been any analysis by Departmental or GWC to try and ascertain whether a program of making use of external consultants will be more cost effective or efficient than attempting to have staff brought in-house with perhaps those same skill sets. And I'm not sure if that's something that's been
Yeah.
considered.
So I think the starting point assumption that I had was that the level of expertise that is required to do the work that is required in a highly specialised area is unlikely to be able to be brought in-house in terms of public service wages. And so getting expertise externally was our starting point. Indeed, not to say that we wouldn't look at being able to employ someone internally. If that was made available as an option, we could definitely look at that to put that to GWC.
And the last question I had in relation to that issue, there's some discussion about the AML program in your witness statement. Are you open to considering similar types of programs with perhaps consultants building a scope of audit or similar for those other matters that you mentioned earlier in your evidence today, junkets, infiltration of the casino, and possibly minimisation of harm from gambling?
Yes.
I'd like to move on now and ask you some questions about the department's auditing of the casino taxable revenue. I've already mentioned before the draft response that the department's put together responding to the Auditor General's review of the current process by which the casino taxable revenue is checked. And are you aware that in that draft response there's a proposal to engage an accredited testing facility to carry out a review of Crown's systems and essentially repeat a review that was last done in 2017?
Yes.
And have you been made aware that the report for that 2017 audit contained multiple recommendations for things that were said the department or the GWC should implement, which recommendations were themselves a repeat of 2015 recommendations?
I'm not aware of that. And I'm not aware of I'm not aware of the detail of that. I have specifically asked the question when I became aware that the work, firstly I asked the question as to whether it was being independently verified, and I was told that it wasn't. And then I asked the question of whether or not, why not? And I wasn't able to get an answer. And when I asked the question of when was the last, has it ever been done? I was advised that it had been done, but the last time that it had been done was 2017. So I asked for why that was, and no one was able to provide me with an answer to that question. And then I said, well, that and anything else that was done in 2017 and has been not done in that intervening period, the GWC needs to have full line of sight of that. Please report back. That is a current action for the department.
Or now I won't take these up on the screen, but just for the benefit of the transcript, the 2015 report is GWC.002.008.001, and the 2017 report is DLG.8001.0045.5733. So I appreciate your answer that you hadn't seen those reports, hadn't been told about the recommendations in those reports not being implemented. My question now, of course, is, given what I've just told you about these apparent recommendations not being implemented, what can you let the commissioners know about your intention to ensure that those recommendations are reviewed and, if appropriate, implemented?
So I think earlier on today I outlined the new structure of the organisation includes 2 new Deputy Director Generals who are responsible for, one is responsible for portfolio coordination, the other one is responsible for portfolio capability. And that person, Corey Dykstra, has now appointed on an interim basis Robin Ho, who comes on secondment from the Department of Premier and Cabinet. Part of her role is overseeing the audit area, and I have made it clear to her that understanding the full gambit of all audit and review work that's been undertaken and the recommendations from both from Office of Auditor General, but also from internal audit and also from within the operational areas, audits or reviews that have been undertaken with recommendations are clearly understood, that there's a clear line of sight, and that there's a clear implementation plan and tracking and reporting in relation to those issues, both reporting upline so that I'm able to report to our ministers, but importantly upline to GWC. And indeed to the other statutory authorities that are involved with the organisation. So that will be one of the elements of the work that she will be doing. I have also commenced regular meetings with the chair of our independent audit and risk committee since my arrival, and have had several free and very frank discussions with him about what needs to happen within the department to address the internal audit findings and the Office of Auditor General findings. I have also met recently and we've agreed to meet, I believe, quarterly with the Auditor General herself to discuss the situation in terms of our ongoing concerns in relation to our addressing of audit findings. And I've committed to both Ms Spencer and Mr Piper that we will improve the audit culture of the department, and that includes ensuring that every single staff member in the organisation has an appreciation of the importance of audit, the importance of the management response being implemented, and that people need to, and we've got systems and processes in place now that will assist that. So the ones I just referred to, plus a training program to be designed and delivered across the organisation in relation to audit, understanding audit, the importance of audit, and the risks associated with us not implementing recommendations from audits. I could not be more. I'm very passionate about the need for regulators to, in particular, but for all public servants, to be absolutely diligent about their response to audit.
Thank you, Ms Chopping. Now, you would be aware that one of the issues that came out of the Victorian Royal Commission was the concern that Crown had been incorrectly claiming expenses and using them to deduct against casino revenue. Are you aware of that?
Yes.
And are you aware as well that there has been an investigation conducted here by the GWC and officers of the GWC in relation to that matter?
Yes.
And we've had the agenda for the July 2021 meeting of the GWC in which that investigation is discussed, and the findings of that investigation. Are you satisfied now, on the evidence available to you today, that it does not appear that Crown Perth was engaged in that same practice of improperly deducting expenses?
I am not yet satisfied.
And can you tell us what further investigations, if any, are being conducted at the moment?
So this item is one of the matters where I've asked for independent verification, and where I have spoken to the Under-Treasurer in relation to assistance that may be provided by Treasury, ultimately, in relation to that issue. There's more work to be done in that space.
All right. In a related question, again, you might not know this, but the 2015 and the 2017 reviews or audits of Crown systems were conducted by a company called GLI Australia, which is that accredited testing facility. Were you aware of that?
I am aware of GLI, but I'm not aware that I don't believe I'm aware. I don't recall being aware that they specifically were the entity that undertook that. Oh, no, well.
The reason I asked that question is not so much about the particular company, but rather because in, I think it's April 2019, there were minutes of a GWC meeting in which it was noted by the then Deputy Director General that Crown Perth is now a client of GLI. This leaves the department with no independent testing laboratory in Australia. And for the transcript, that references GWC.000016.0274 at page 4. So I don't know the current status of whether it's the case that Crown is still a client of GLI, but if they were, what would that mean as far as you are concerned as to the suitability of using a company like GLI to conduct an audit?
So, the satisfactory or otherwise nature of testing facilities and indeed their ability to be able to undertake work both for the regulated entity and the regulator is a matter that it will be under or is under active consideration as part of the regulatory review. It was discussed on Friday in relation, I believe there was either at the GWC meeting or immediately after the GWC meeting, there was a discussion between myself and members as the meeting was ending, where the issue about the independence of independent testing facilities was discussed. And I indicated at the time that we will need to look at that issue.
And in terms of looking at it, I appreciate this is all very new, you might not have a fixed view. Is this an issue where you think it may ultimately be necessary for either the department or the GWC to have its own expertise in-house to avoid the sorts of issues of independence that apparently have occurred in the past?
So it's too soon for me to say that it would be an in-house expertise. But definitely we would need to, if it was proven that the testing facility wasn't sufficiently independent, then we would need to look for an alternative to that. Bringing resources in-house may well be one of those alternatives. That said, in my experience in other regulatory systems, the testing facility concerns with testing facilities are not unique to and their appropriateness or independence is not unique to casino regulation. It's an ongoing concern for regulators more broadly. And how to address that, whether you rebuild technical capacity within your own regulator or whether you use alternates or you develop alternates that are offshore, for example, are practice considerations.
All right, so there's one final question, or rather issue, I'd like to ask you about in relation to taxation. And this deals with the manner in which the conversion of reward points from Crown Reward loyalty members into gambling products is treated for the purpose of taxation, whether it's treated as revenue or not treated as revenue. So can we please bring up PCRC.0002.0019.001 and have pages 8 and 9 side by side. And just while that's coming up, this is one of the Section 8A answers that you provided to the PCRC in response to a request for a statement. So at the bottom of page 8, you explain your understanding about how the conversion of points for use in table games works. And then onto the next side, top of page 9, you explain how your understanding is as to the conversion of points for electronic gaming machines or EGMs. I'll just let you read that to remind yourself.
So can I just say, the notices to produce are not written by me.
They're just under your hand.
As the accountable authority, but the volume and the nature of the...
I don't say that critically. I'm just confirming that.
Sorry. Yes. I do, unless I'm unavailable, in which case the Deputy Director General would sign that. Okay. Sorry.
Perhaps I'll ask this question then. Is it the case that you've had the opportunity to give independent consideration and thought as to the treatment of the taxing aspect of loyalty conversions for table games versus loyalty conversions for EGMs?
I think further work needs to be done in this space for the GWC to be appropriately informed and satisfied of the way in which this matter and a range of other matters work.
All right. Well, I perhaps don't need to go through this in great detail then. The point that I was going to suggest to you is that there is differential treatment for the conversion of loyalty points, depending whether it's table games or whether it's EGMs. It appears to be, based on your answer and our understanding as well, that if you're converting loyalty points and using them in table games, then vouchers are produced and those vouchers are counted as revenue and the casino ultimately pays tax on them. But if it's the case that you're using the conversion of loyalty points for electronic gaming machines, then there is no tax paid on that conversion, notwithstanding that the process of using that conversion requires a patron initially spending their own money. So having had me explain that in those terms, would you accept that that seems inconsistent?
Yes, and yes. Yep.
And having again had me say that to you and realising I'm putting you on the spot, is that something which you consider might be appropriate to have further consideration or advice?
Yes.
Commissioners, if that's a convenient time, then that's the end of that topic.
Certainly, Mr Lee. So we will take a break for 15 minutes, which takes us to about 25 minutes past 11. Ms Chopping will take morning tea now, and we will adjourn.
All rise.
Thank you. Please be seated. Yes, Mr. Lee.
Thank you, Commissioner. Ms Chopping, I'm now going to ask you some questions about responsible service of gaming, or RSG. First, at a very basic level, would you agree that the notion of responsible service of gaming encompasses having measures, restrictions or conditions on the manner in which gambling operators can provide gambling services so as to ensure that the harm caused by those services is kept to the minimum reasonably possible?
Yes.
And secondly, are you aware that one of the duties of the GWC, imposed by Section 7(1)(ba) of the GWC Act, is to formulate and implement policies for the scrutiny, control and regulation of gaming and wagering, taking into account, amongst other things, the need to minimise harm caused by gambling?
Yes.
What do you understand to be meant by that obligation?
Twofold, that there should be proactive policy expectations and program expectations set for the regulated entity that are likely to that are capable of being evaluated or audited and observed to be effective. Secondly, that in approving other elements for the regulated entity in terms of games or other procedures and policies, not do anything that would not allow anything to be done that would inadvertently cut across that, or cause a negative outcome.
And at a broad level, recognising that
Yes.
it may be too
Yes.
early for you to say in any great detail, what's your view as to how the GWC should discharge these obligations of developing policies? With what degree of specificity or control should the GWC be exercising these policies?
So it is too early for me to say with anything other than a broad statement, which is that forming a foundational agreed understanding at GWC of their purpose and the nature of the harms that exist in the market, and then the opportunities that currently exist for those harms to be ameliorated, and the degree to which there's a gap there. And then looking at the range of options that might be available if you were to take further regulatory intervention into the system and what that might look like.
Now, would you agree that before the GWC could be in a position to devise appropriate policies to deal with minimising the harm caused by gambling, it would first need to know how much gambling harm there actually is?
Yes.
And in order to know that, it would have to have access to comprehensive, up-to-date research?
Yes.
And would you also agree that the gambling environment in Western Australia is quite different to the gambling environment in many other states and territories because, for example, they have poker machines in hotels and clubs, whereas we don't have that here in Western Australia?
Yes.
So there'd have to be bespoke research for WA?
Yes.
Now, the PCRC understands that the last research into gambling prevalence in Western Australia was conducted by the Productivity Commission in 1999. Are you aware of that report?
Yes, I am. I'm not currently familiar with the detail. I'm aware of the existence of the report, but the detail of the report I'm yet to review.
And I should note for completeness that the Productivity Commission did do a follow-up report in 2010. However, in that report, they expressly noted that they did not carry out a further national survey. And they also noted in that report that WA had not itself independently carried out any survey work since 1999. And for the transcript, the document reference to the 2010 report is PUB.007.0014.1100 at page 86. So putting aside those Productivity Commission reports, are you aware of any other up-to-date research specifically dealing with the WA context?
So upon my arrival in the department, I asked the question as to what mechanisms were in place to address harm minimisation and problem gambling, and was advised of the existence of the problem gambling support services subcommittee, and I made inquiries as to the contingency of that committee and its work program, its terms of reference, and whether or not it had commissioned research in relation to the current circumstance, the baseline of what harm looks like in Western Australia from from problem gambling, and received advice. Information has then been provided and will continue to be provided on a monthly basis to GWC as part of a standing item on the agenda. That group has been tasked with commissioning of research into that foundation baseline harms of gambling in Western Australia, and understand that they have made approaches to 2 universities and have received a response from one university and are waiting on the response from the other university.
Right, so just circling back to my question, in relation to whether you're aware of any other existing research, is the answer no, but that there is some research about to be undertaken?
Yes, I'm not aware of any fulsome research about Western Australian problem gambling that's in existence. I do, however, note that amongst financial counsellors, community legal centres, welfare service providers, there is anecdotal information around the impact of gambling, but I wouldn't take that information as the foundation for the kind of research that GWC would need to make an informed decision in relation to what its regulatory approach on problem gambling will be in Western Australia going forward.
And understanding that there's now been some engagement with the universities, and obviously there's a dialogue going on there, are you yet in a position to know what is likely to be the cost of any research?
No.
And if that cost was to be substantive, perhaps more than could be borne individually by the GWC or the department, do you think it would be appropriate to be approaching government to seek whatever costing might be required to provide comprehensive quality research?
Yes.
I'm going to touch now on some of the specific policies that the GWC has in relation to harm minimisation, and in particular, I'm going to ask you about the ATM policy, or the ATM FPOS policy, which I understand was approved, or a revised version was approved by the GWC at its June meeting, which was the first meeting where you were there as the chair. Is that correct?
Yes.
And do you recall the item being considered, the ATM policy?
I do, but I don't recall the detail of it. I do recall there was a discussion about the use of FPOS machines.
Well, I'll just call up the policy for you to see.
Thank
So
you.
that's PUB.0028.0001.001, and if we can please have pages 1 and 2 side by side. So while that's coming up, the essential change was that previously the policy had dealt solely with ATM machines, and then subsequent to the amendments, it introduced the instructions in relation to FPOS and contactless payments that you can see on page 1. Taking you first to page 2, the ATM section, and you can see there that the first paragraph explains that there are restrictions on the placement of ATMs in Crown Hotel, and the second sentence says, limiting access to ATMs encourages patrons to have breaks in play as part of harm minimisation requirements. Now, does that explanation that's in the policy match your own understanding as to why this policy exists?
It matches my understanding of the advice that GWC received in making its decision in relation to this issue.
Would you agree?
Whether or not that initiative or that decision actually results in the intended harm minimisation is a matter that I believe requires further analysis. So I think I said before about the evaluation of intervention strategies that the regulator puts in place, or rules that the regulator puts in place, is really important, because sometimes regulators will be in a position of making decisions where they think the thing that they're doing is actually creating that outcome, but in fact it creates a perverse outcome, or it doesn't actually do anything to impact the issue.
What I want to draw your attention to is that explanation as to encouraging breaks in play seems to be directed to the situation where a person goes to the casino with a certain amount of cash, they lose that cash playing on a game, and they're then forced to get up and leave the table and head outside to an ATM machine to get more money if they want to keep playing. That gives them a chance to clear their heads and decide whether they really think it's a good idea in the process of the walk. Does that general explanation match your understanding of what is there at the second
Of what
part
the
of ATM
intention
policy?
is, yes.
And the reason that I asked that question
Yep.
is because of the changes that have now been brought in, which you can see under the FPOS contactless payment system, talks about how it's now possible for patrons, and this is in the second paragraph, they're permitted to purchase gaming chips at designated areas in the casino, at a gaming table, or at ticket redemption terminals. So do you see that that seems to be inconsistent with what the ATM policy was trying to achieve?
Yes, I do. And can I say my recollection of the discussion that surrounded this item was in relation to the limiting of cash within the casino. Members, if I recall correctly, the members' intention was that it would be a safer option for people to be using a card rather than handing over cash.
In terms of hygiene?
Both hygiene, but also in terms of the concerns that have been raised about organised crime or other tracking of people within the casino, because it's easier to be anonymous if you are a guest, for example, with cash, than it is if you are someone who's paying via a recordable measure.
So are you suggesting this might be a situation where a desire to try and be cognizant of money laundering perhaps is pulling in a different direction to harm minimisation? Is that right? If I understood your answer correctly.
No, I'm not saying that. But what I think I've said all along today is that one thing that strikes me is that the GWC hasn't been well informed in relation to foundational information about the nature of harm, nor has it been doesn't appear to be well informed in terms of exactly what its choice is in terms of the regulatory approach. So the frame for making decisions is not always clear for them, or for us. Yeah. So hopefully going forward that will improve.
All right. So it sounds from the answers that you're giving that you consider there might be some difficulties here with this policy that require further consideration. Is that a fair way of summarising it?
Yes.
Accepting that, I still want to draw something further to your attention, and that's not in relation to the framework, but in relation to the way this particular policy has been implemented. I'm going to call up a document now, but can it please be shown only on the screens of the commissioners and the witness, and that's GWC.0012.0001.001 with pages 247 and 248 side by side. And Ms. Chopping, just let me know when you have that before you. And I'm going to try and draw your attention to the bottom of page 247. Oh, it hasn't come up yet?
No.
No, okay. They might be having some technical difficulty. Perhaps I'll just explain to you that the dot point I was going to draw your attention to details the particular way in which the policy is implemented, and it explains that there's a daily withdrawal limit from terminals.
It's there now.
Thank you. And that's the second dot point, or rather it's the second paragraph, first dot point on page 248.
I think we're currently on 248.
Begins with the words a daily withdrawal.
Commissioners, I'm sorry to interrupt. Was it Council Assisting's intention that the Council would not have access to this document?
Yes, that's right. There's presently an MPO application in relation to this document which hasn't yet been determined. So if you have the words a daily withdrawal limit.
No. Sorry, can you? Oh, yes.
All right. So the point that I want to draw to your attention there is that there's obviously a limit in place to ensure that people don't withdraw too much money at a table. Would you accept that?
Yes.
And you can see that there's been a decision made as to when to treat a day as being a new day, so as to allow for a certain amount of money to be withdrawn only in any given day.
Yes.
And you can see that the decision that's been made is to have that date reset at midnight.
Yes.
Now, would you agree that, as a general proposition, people at midnight are more likely to be people who are drunk and tired?
Yes,
and therefore perhaps people more likely to be making impulsive decisions.
yes,
And so therefore having a time reset at, say, midnight rather than midday could result in persons withdrawing their first amount of money before midnight and their second amount of money after midnight.
yes.
And you might not be able to see all of this on the screen in front of you, but there's no reference in this policy to there being any kind of protection or checking to make sure that people don't use more than one type of bank card. So that if they had multiple accounts, they could be taking out multiple sets of money before and after midnight.
Yes.
So would you agree, having gone through those aspects of the policy together, that this is a policy which perhaps has not had a sufficient degree of attention to potential harm minimisation aspects?
Yes, I do. And I think, as I've said, there hasn't appeared to have been a strong focus in relation to a clear frame in the papers that have come forward, a thorough analysis in relation to the potential harm impact associated with decision making. It's been more on the other element, which is I'll rest there.
All right.
Thanks.
Well, the next thing I'm going to ask you about is some of the information that is provided to the GWC in relation to RSG or harm minimisation aspects. And these are statistics which come from the Perth Casino and are put before the GWC at its meetings. Now, you're nodding, so do you understand the document I'm referring to?
Yes, I do. Yes.
I'll just bring up an example for you to take a look at, and that's GWC.0012.0001.0603, and this is at page 1008. And this should please be on all the screens. Now you can see in those minutes there that you are present as the chairperson at the top, and this is for the 22 June agenda. And so when we get to page 1008, we have the cover document, the agenda item from the officer, and you can see there's a recommendation to note the report. And if we then move forward, please, page by page, you can see first security report incidents from the casino, and then moving to 1010, there's some discussion here as to what the stats show. And in particular, I draw your attention to item 2, which explains that there had been a change to play periods in January 2021, such that previously Crown had allowed people to be on site for 24 hours, and now they were changing it to 18 hours. And that information is given to you to explain what might be seen as being a bit of a spike in the number of people being detected who are playing over that time limit. So if we can go to the next page, please. I think it's one further page. Maybe 2 further pages. And then down the bottom there you've got play period, where you can see there's the number of persons who have been found to be staying beyond that time. Were these statistics gone through by the GWC in the course of their meetings?
The statistics are tabled, but there was it was at the how it's operated. This is bearing in mind this is my very first meeting. How it has operated in the past and how it has been operating is that this is provided, the reports are provided with very little analysis of of change in trends other than the percentage, and very little analysis, despite those the previous slide, very little analysis of what that actually means for the GWC in terms of the broader context. So things are left sort of hanging there as definitions or as information, but there's not a lot of analysis that would lead the GWC towards making an informed decision, I don't believe. And there's a significant need for improvement. The documents have been put to GWC as being, well, here they are, essentially, if you've got any questions, now's the time for discussion. Now, in my opinion, that's not the best way for the GWC to operate or be supported or advised by the department.
Yeah. So this is obviously in relation to what was going to happen in the June meeting. Subsequent to that, there's been the July and the August meetings.
Yes, and I would say there's minimal, if any, improvement, but there has been significant improvement in the agenda papers from June to August.
My point was going to be that the minutes for these meetings show that in each case the GWC notes the report as is recommended by the officer, but there's no discussion in the minutes to suggest that there was any consideration by the members at that meeting as to the statistics or what they meant. Does that fairly reflect what's actually happening?
The meetings we started recording the meetings now, so there's a full transcript of the meetings and the recordings are kept for 12 months. So
what I'm really asking you is that, given the minutes simply say noted, thinking back from your perspective, is that fair that there wasn't in fact any discussion about these items at the meetings?
I can't recall whether there was discussion or there wasn't discussion. My opinion is that there should be further analysis and further discussion.
I'm now going to show you the minutes for the July 2021 meeting, which is GWC.0012.001.0250. And if we can please call up and go to page 18. When this comes up, you'll see this is in relation to a discussion about the PGSSC. So it's not in relation specifically to RSG statistics, but there is a
confined to just the personal screens.
certainly from my perspective, that's fine. Can that please be changed as requested? So you can see in front of you, not yet, if that can please be brought up on the screens for the witness and the commissioners. And Ms. Shopping, if you can let me know once that's successfully up.
Now.
All right, now if you can please take a look at the second paragraph under item 11.7. And there's a second sentence where there's some discussion about the length of time people are allowed to gamble.
Difficult to see about what would be contentious about this page,
Well,
Mr.
I was
Garrett.
going to add to it this, Commissioner, there's no difficulty with other council seeing the document as well, but understand that the document has been the subject of an application. Particular pages. It is just one particular page, Commissioner. Provided it's not that page that's displayed, I don't have any trouble with the document otherwise going
The
up.
page that we're seeking to go to is 18, so if that's not the page you're concerned with.
No, that'd be fine. Thank you.
Very good.
Thank you. So we have it here now, and you can see in the middle paragraph under 11.7, starting at the end of the paragraph in the second line, this is currently 18 hours.
Yes.
And members agreed that this seems too long. So it appears that there was some discussion there about time limits in the context of this particular item. Do you know where the 18-hour reference comes from in that paragraph?
No.
Do you think it may have come from that earlier document we were looking at, the statistics with the note saying how Crown had changed its time to 18 hours?
Maybe. I don't know.
By the reference to...
Can I just say, sorry, starting in June, ostensibly, and then July and August being my third meeting, there is a lot of content that's discussed that's unclear to me whether it's new content that's just arrived for the GWC or if it's historical knowledge that people have who've been involved in the GWC. So I don't know.
Understood.
Yep.
There's a reference there to a concern that this might be too long. And by that, do you understand, or did you understand at the time, too long to mean long enough so as to actually pose a risk to patron welfare?
in terms of the discussion that surrounded this item as minuted, that currently 18 hours is too long.
So obviously you were at the meeting. And
Yes.
what was meant by the words too long? What was the concern?
That it's that GWC members don't feel that 18 hours is an appropriate amount of time, and that time should be looked at in terms of further research commissioned by the PGSSC.
So I'm just going to press you when you say not an appropriate length of time.
Yeah.
My question is, because it would do what? What's the result that you're concerned with as a result of the time? Is it because too much money is spent? Is it because people are away from their families? What's the concern?
That it would cause that it would cause harm. But can I say, in terms of what would be the appropriate amount of time?
Yes.
I don't think GWC is in a position to be able to make a well-informed decision about what the appropriate amount of time would be. But I think it's clear from the discussion that some members at least think that 18 hours is too long.
Are you, on that point about what might be the correct length of time, are you aware of the GWC or the department ever being advised by Crown as to existing research dealing with the length of gambling times?
I am not aware personally, no.
I'm just going to bring up a document which is CRW.510.073.1240, and if that can please be taken to page 8. While this is coming up, this document was an attachment to an email that was sent by Miss Sonia Bauer, who is currently Crown's General Manager of Responsible Gaming, and it was sent on 26 March. In the body of the email, Ms. Bauer describes the document, along with other attachments to the email, as seminal research. So at page 8, under the heading Length of Playing Sessions at the bottom, you can see there's a comment there as to, well, the second sentence, while most may not agree at the lower end is indicative of something serious, certainly 5 to 6 hours and beyond would raise concerns. Do you see that?
Yes.
Does that comment cause you any concern as a member of the GWC?
Yes.
Going back to page 1 of this report and looking at the bottom of the page, there's a date that shows when the report was generated. I think you can see that says August 2002. Do you consider that this sort of research should already have been identified by the department and provided to the GWC for its consideration?
Yes.
And do you think that the fact this research apparently was not known to the members or departmental officers at the time of this meeting might suggest that historically there hasn't been a sufficiently clear focus on RSG and harm minimisation?
Yes.
In relation to time limits now, I'm just going to take you back to the June 2021 meeting agenda, and this is GWC.001.0001.0603 at page 156. And this is agenda item 6.5 when it comes up. It's an agenda item providing various research papers and other documents from Crown Perth to the GWC. So you can see there under background, the second paragraph, there's a reference to attachment 1. And you can see it explains that summary of reports that have come from the casino. And if we go forward to page 159, please. And you can see in the middle of the page there, next to 26 May 2021, there's responsible gaming enhancements. And it's referring to attachment 11. And if we can please go to page 573, we'll have attachment 11. Now, this is a cover letter explaining that Crown's about to make some changes to its systems to enhance its responsible service of gaming. And if we go forward 2 pages now to page 575, there's a table that sets out what's being proposed by Crown. And the first item there is time limits on play. And I'll just draw your attention to the second dot point for domestic players. You can see there it's proposing that it be changed to a 12-hour per day time limit. So having taken you through all those documents, my point or my suggestion to you is, it appears that no members of the GWC at the meeting had actually read or appreciated this document, because they were still referring to 18-hour limits as opposed to 12-hour limits. Do you agree with that?
Well, I agree that they were referring to 18-hour limits. I don't know whether they had or hadn't read the information.
Would
But-
you
but-
accept that it appears they wouldn't have retained the information?
Yeah, definitely. And neither did I.
And again, do you think that that might still indicate that there is as yet perhaps not quite the focus on RSG that there is required from the GWC?
Yes.
Moving on now to some different questions in relation to electronic gaming machines.
But can I just say that also in terms of the level of analysis that's been done today of the remediation impact, that there's significant amounts of further work that are required in terms of departmental staff. There's capability issues, and there's also significant amounts of work that are required during what is an extremely disrupted period time. So as I referred to in the beginning, in terms of the loss of corporate knowledge and the loss of critical staff, the rebuilding of those teams at a time of incredible disruption, where the same people are also involved in responding to the Royal Commission, they're involved in a whole range of other things. So it is a very difficult period. That said, I totally agree that GWC needs to be better supported and more well informed in relation to RSG and harm minimisation in an evidence-based way, not reliant on the proponent. Yes.
Thank you, Ms. Chopping. As I said, I'm going to move now to a different topic area altogether, which is in relation to electronic gaming machines. And I'm going to ask some questions about the process by which those EGMs are approved. And I'm taking it by your intake of breath that this might not be something which you are intimately familiar with.
That is correct. So, yeah, but let's have a go. But
Well, we'll call up to start with PCRC.002.0014.001, and this again is another one of the Section 8A notices that came again under your hand, but it might be the case that you haven't had very significant involvement with the answers to the questions. If you can look at the bottom of page 3 first, which is the one on the left, you've got question 6. And I'll just let you read that question and answer to yourself for a moment.
so I've read the answer. Yes.
And is that something that you can recall being discussed with you at the time when this question came through?
No.
All right.
Can I say
Yes.
the second week that I was in the job, I asked to see General Counsel and the other lawyer within the organisation and asked the question, tell me who provides advice for legal advice for GWC and for the department in relation to gaming-related matters. And I was surprised to hear that there was very little expertise in relation to gaming regulation that existed within the organisation from a legal point of view, which was alarming to me. And subsequently, I've taken steps to ensure that we have ongoing legal lawyers to provide advice in relation to gaming-related matters.
Without telling us, again, the content of any advice, can you just give the Commissioner some more detail as to what steps have been taken so that legal advice is available in the future?
Yeah. So in the first instance, I wrote to the State Solicitor requesting a secondment of an officer to come to the department to review our in-house counsel services that are provided. When I arrived in the department, it was very different to what I'd experienced in my previous employment in terms of the level of service that's available in-house for performing regulatory functions. I did, as I just indicated, ask the question how legal services are provided in relation to our racing, gaming and liquor areas, and pretty much most of the questions that I've asked about, well, where do you get legal advice in relation to those matters, have been answered along the lines of, Mick Connolly would deal with those issues. Mick Connolly would deal with that, which was really concerning to me. So I wrote to the State Solicitor, asked for a secondment to come and look at our legal services. We are still in discussions about that occurring. We did secure, we thought, a proponent from the private sector who would be able to provide senior legal services within the agency for a period of time, just to establish a legal practice kind of approach for racing, gaming and liquor. However, just prior to the arrangement being solidified, they pulled out at the last moment because of a conflict of interest matter that they raised. And so finding a suitable legal firm to provide those services has been proved really challenging because of the conflict of interest issue. Subsequently, the State Solicitor has agreed that we will work on a temporary arrangement whereby legal advice can be procured from the State Solicitor's office until we're able to actually formulate for the whole of the department what our approach will be, and specifically what the approach will be for GWC. So part of the work around GWC's forward work program is to look at the question of the provision of legal services for gaming related matters and what the costs might be involved in that and what the best arrangement might be for that to occur.
So given that explanation that you've just given to the Commission, you might not be able to answer this next question, in which case we'll simply move on. But the question was going to be in relation to what's said at the bottom of page 3 or underneath question 6, where there's a comment to the GWC being obliged pursuant to clause 22.2 of the Casino Burswood Island Agreement Act 1985. Now,
Yep.
the reference here is to a state agreement, which is a contract. And my question was going to be, why is the GWC not a party to that contract, obliged by the terms of that contract? But again, that might not be something you can
It's not
answer.
something that I can comment on now,
All right.
but I can say that my the current way that notices to produce are produced is under the supervision of, or under the general counsel produces delivers up the notices to produce. That is my understanding of how we're currently operating, and that therefore I would take the notices to produce as having been approved by a suitably qualified person to make that assertion.
All right. The GWC has provided Section 8A notices to the PCRC in which it adopts the answers given by the department. Were you consulted as part of the GWC as to whether that should be done?
I don't believe so. I don't recall being consulted. I don't believe so. It may be that it's an arrangement that was in place under the previous Director General and under the previous as Chair.
All right. Now, moving to the next issue, and again, you might not be able to answer this in light of what you've previously said, but question 5, which is a bit above, deals with whether or not the GWC is obliged to make variations to the rules of authorised games at the casino. And you can see in a second paragraph it says the department understands that the GWC is required to approve variations of video bingo or arashinko. Now, is that something that you have any understanding or knowledge of?
I think I think it's either inaccurate or it's an extremely poorly worded sentence.
And why do you have the view that it's inaccurate?
Now that, particularly after we've just discussed item 6, I'm feeling quite concerned about the legality of the statements that might oblige or require GWC to do something or not do something.
All right. There's a discussion there in relation to, I think it's in the same paragraph, where it says the department's understanding is that in order to obtain approval, Crown must provide a video demonstration of the approved game, the previously approved game, and the proposed variation. Is that something which you're familiar with, or is that something which you're not familiar with sitting here today?
I do understand that Crown has provided in the past those presentations. It hasn't provided those presentations since in the 3 meetings that I've chaired. Yes, that's what.
If I can ask in broad terms,
Yeah.
do you understand that there's a distinction between authorising a brand new game to be played at the casino versus approving changes to rules of an already authorised games to introduce a variation of that game? Is that the concept with which you're familiar?
Yeah, that there's a difference, but the detail of the differences I'm not familiar with at this point.
All right.
In the short time that I've been there with the agency, I've been attending to a number of remediation issues that I talked about initially. The getting my technical knowledge around the regulatory requirements on game approval hasn't been a focus of my tenure so far. So I've been very reliant on the advice of staff yeah.
The reason I had wanted to take you to these games in this line of questioning is because the answers given to the PCRC suggest that the understanding of the GWC and perhaps the department is that variations to games can be approved and the rules changed so long as that they are variations to games and not new games. And I'm proposing to play some videos for you to consider in relation to what those games look like for Arashinko and Video Bingo so that you can see the distinctions between them. And the reason I want to do that is I want to ask for your perspective going forward as a member of the GWC as to whether you would consider such changes to be variations of a game versus new games if you were to be given games to consider, or rather if you'd be given an application to consider for rule changes in the future. Does that make sense?
It does make sense, but
So, Ms. Chopping, can I say that I think I understand your concern. Mr. Lee will show you these. If as a result of being shown them you don't feel that you can accurately, honestly answer the question which follows, then just tell us.
Okay, thanks.
So what I'm going to do, Ms. Chopping, is the first game I'm going to show you is called Arashinko. That's one of the classes of authorised games at the casino. The next game I'm going to show you is called Fireball Bingo, and that is a class of game known as Video Bingo. So can we please bring up GWC.001.005, actually, no, I beg your pardon, that's the authorised rule list. If we can please bring up CRW.700.062.1032. And while this is coming up, I'll let you know that the game that you're about to see is called Arashinko, and the minutes of the GWC meeting where it was first approved suggest that it's based on a Japanese game known as pachinko. And if that can be played, please. But with sound, please. Yes, thank you.
The name of this game is Arashinko. This game was approved prior to the introduction of on-screen game rules. Accordingly, the rules of this game are displayed in a static artwork panel installed in the EGM top box. These displayed game rules include information regarding the bonus features in the game. The initial bet selection process for the game involves 2 steps. 1. Select a number of buckets to play. 5 options are offered from a minimum of 1 to a maximum of all 5 available buckets. 2. Select a credit value to bet per bucket. 5 options are offered with the minimum option always being 1 credit per bucket. The other options offered may vary from a minimum of 2 credits to a maximum of 20 credits per bucket. After making their bet selections, the player must press a separate play button to commence gameplay. After the player makes bet selections for their first played game, if they wish to play subsequent games utilizing the same bet selections, they can do so by pressing the play button only. When installed on the gaming floor, the game can be configured by Crown to operate at varying approved denominations, ranging from 5 cents to $1. Accordingly, configurable bet values can range from a minimum of 5 cents on a 5 cents game to a maximum of $100 on a $1 game. This game is currently configured to operate at a 5 cents denomination with a maximum bet of $5. The game does not incorporate any jackpot or bonus prizes. Crown is unable to confirm the exact minimum speed of play at which the game software has been developed to operate. Here is a demonstration of how quickly a player may be able to commence subsequent games.
Now, Ms. Chopping, have you ever seen that game before?
No,
Okay. So
I'm not, yes.
having listened to the explanation and watched the video as it was playing, did you note that the features that were pointed out was that the game had a number of options that you could bet on the number of buckets you wish to bet? So that's the first option you could select.
Mm-hmm.
And the second thing you could do is bet a number of credits per option selected, per bucket selected. And then lastly, thereafter, you simply hit the play button to start the game. Would you agree that all those things were what appeared to be the features of the game that we just saw?
Yes.
And that the game was random in the sense that once the play button was hit, the player had no further interaction.
Until they pressed it for
Until
the
they
next,
started the
for the
next
next
game.
one. Yes, yep.
So having looked at that game, I'll just let you know again that that was the original game for the authorised game of Arashinko, which is in the rules of the casino. The next video I'm going to show you is for a game called Fireball Bingo, which was the original game for the game category known as Video Bingo.
Mm-hmm.
So that's CRW.700.062.1030. And you'll see when the video actually plays, the graphic interface is suggestive of a traditional game of bingo in that there are balls with numbers on which are selected from the game.
The name of this game is Fireball Bingo. This game was approved prior to the introduction of on-screen game rules. Accordingly, the rules of this game are displayed in a static artwork panel installed in the EGM belly panel. The initial bet selection process for the game involves a minimum of 2 steps and an optional third step. 1. Select a number of bingo cards to play. 5 options are offered from a minimum of 1 to a maximum of all 9 available cards. 2. Select a credit value to bet per card. 5 options are offered from a minimum of 1 to a maximum of 5 credits per card. 3. The game offers the player the option to randomly change the displayed cards if desired. After making their bet selections, the player must press a separate Start Game button to commence gameplay. After the player makes bet selections for their first played game, if they wish to play subsequent games utilizing the same bet selections, they can do so by pressing the Start Game button only. When installed on the gaming floor, the game can be configured by Crown to operate at varying approved denominations, ranging from 1 cent to $1. Accordingly, configurable bet values can range from a minimum of 1 cent on a 1 cent game to a maximum of $45 on a $1 game. This game is currently configured to operate at a 5 cent denomination with a maximum bet of $2.25. The game does not incorporate any jackpot or bonus prizes or features. Crown is unable to confirm the exact minimum speed of play at which the game software has been developed to operate. Here is a demonstration of how quickly a player may be able to commence subsequent games.
All right, so having watched that video, and again, I understand that I'm putting you on the spot because it's the first time you've seen these things, but would you agree that what we've just looked at was, again, a game which had first a number of options for betting strategy, as it was called, which selects the number of cards as opposed to the number of buckets in the previous game?
Yes.
The second option was the amount of credits to be wagered per the card selection. And then the final thing to do was, once again, hit the play button for the game to commence. Would you agree with all those?
Yes.
So would you agree that in that respect the games were very similar in that you have the same steps to play? Choose the number of things to bet on, choose the amount of credits to bet on per option you've selected, and then hit the play button.
Yes.
Would you agree that the primary distinction between those games is visual?
Yes.
In terms then of the fact that those two games were both different authorised games, that is, the distinctions between them were enough for the GWC to see them as being wholly separate games as opposed to variations of each other. Are you following my
Yes,
point?
yeah.
Would you accept that a visual distinction appears to have been sufficient for the GWC in the past to consider a game a separate game?
I'm not sure I can answer a question about what the GWC has seen as being sufficient in the past. Perhaps once I become more educated in relation to the actual technology and the regulatory framework as it pertains specifically to EGMs, then I might be in a better position to answer the question. But at this stage, I'm not sure how to answer the question.
I understand your hesitation. I'll show you now one final video for you to consider. Those two games that we looked at before were approved in 2002 and 2004. The next game I'm going to show you was approved much more recently, I think in 2015. This is a video game called Cats, Hats and More Bats, and the video is CRW.700.062.1036. I'm going to ask you to watch the video and then after I'm going to ask some questions about that.
The name of this game is Cats, Hats and More Bats Locket Link. The game incorporates on-screen game rules pages that can be accessed by pressing the information icon on the main game screen. These on-screen game rules include information regarding the bonus features in the game. The initial bet selection process for the game involves 3 steps. 1. Select a game denomination to play. Either 4 or 6 options are offered, with values ranging from a minimum of 2 cents to a maximum of 50 cents. 2. Select a number of balls to play. 5 options are offered from a minimum of 5 to a maximum of all 15 available balls. 3. Select a credit value to bet per ball. Between 2 and 5 options are offered with the minimum option always being 1 credit per ball. The other options offered may vary from a minimum of 2 credits to a maximum of 10 credits per ball. After making their bet selections, the player must press a separate play button to commence gameplay. After the player makes bet selections for their first played game, if they wish to play subsequent games utilizing the same bet selections, they can do so by pressing the play button only. When installed on the gaming floor, the game can be configured by Crown to operate at varying approved denominations, ranging from 2 cents to 50 cents. Configurable bet values can range from a minimum of 2 cents on a 2 cents game to a maximum of $100 on a 50 cents game. This game is currently configured to operate at multiple denominations from 2 cents to 50 cents, with a maximum bet of $50. The game incorporates 2 jackpot prizes and 2 bonus prizes, which are displayed in the EGM top box. The values of the 2 jackpot prizes increment, reflecting a set proportion of the money wagered on all linked Locket Link EGMs. The values of the jackpot prizes offered remain the same regardless of the value of a player's bet. The 2 jackpot prizes offered can be won during the course of playing the game. The 2 bonus prizes have fixed values. The values of the bonus prizes offered vary based upon the game denomination selected by the player. The 2 bonus prizes offered can be won during the course of playing the game. Crown is unable to confirm the exact minimum speed of play at which the game software has been developed to operate. Here is a demonstration of how quickly a player may be able to commence subsequent games.
All right, so once again, a lot of information for you to take in from that video. Have you ever seen that game before?
No.
So you wouldn't be aware of whether it was approved as a variation of Arashinko or Video Bingo. You don't have that knowledge.
No.
Do you agree that the game had some similar features to both Arashinko and Video Bingo in the sense that you again selected betting options, then selected credits, and then hit a play button to start the game?
Yes.
And again, the game was random in the sense that once you hit the play button, you didn't take any further part in the game.
Yes.
Would you agree that visually the game is dissimilar to both the original Arashinko and Video Bingo that you saw?
Yes, but from my memory now, the first one and the third one were more similar to each other than the middle one.
In terms of similarities, would you accept that the third video that we just watched is as different from both the first two videos as the first two videos were different from each other in terms of the visual look of the game?
Yes, but I'm not really sure what I'm comparing it to. So it's very hard for me to answer the question.
All right.
I don't want to argue with you, and it sounds logical.
I won't press any further.
I think really when I first was appointed to the job, and I did consider going to. I'm glad I didn't, because then I later read the next day I read the legislation and found that it was actually unlawful for me to play any games. But I thought it would be useful, as a regulator, it is useful to have some level of experience and contact with with what goes on. So I did jokingly say that I should go incognito over to the casino just to get a feel for what actually happens there. In terms of the gambling, but I haven't done that, and so I am starting from a very different space in terms of my familiarity with the technical specificity of the games.
All right, I won't press you any further in relation to the visual aspect,
Thank
but I will
you.
ask you one
Okay.
last question about the games. Did you note that the final video we showed talked about the fact that game had jackpot features, and that
Definitely.
neither of the first two games had a jackpot feature?
Definitely, yes.
Would you consider that to be a substantive difference between the third game and the first two games that we looked at?
Yes.
And again, you may not feel that you can express a view, and please don't if you don't think you can, but in your view, was the third game a game that could be characterised as a variation of either of the first two, or was it a different game?
I think it could be not understanding the context.
Well, in that case, if you...
Okay, I won't answer. No.
All right. The last question I have, and unfortunately it's still in relation to EGMs, so
Okay.
it might be a difficult one for you to answer. Are you aware from your most recent meetings at the GWC that there is an ongoing issue between the GWC and the casino as to the speed of play of EGMs and the way in which that is measured?
Yes, I do. I am familiar with the issue of speed. I was working on the basis that there was a speed standard that had been set, and I was surprised when I just saw the videos and heard reference to the fact that there's no way of being able to tell the speed, but here's a demonstration.
Now, not so much looking at those historical videos, but in terms of what you understand to be the current issue between the GWC and the casino as to speed of play, are you able to articulate to the commissioners what you understand that issue to be?
No.
All right. Actually, I don't think I can take that any further. Commissioners, those are the only questions I had to ask.
Thank you very much, Mr. Lee. Now, any counsel who would like to cross-examine? Miss... Mr.
I do,
Garros.
thank you, Commissioner. Ms. Chopping, my surname is Garris and I act for the Crown Companies. Just have a few questions for you. Operator, could you please bring up document GWC.0004.0015.0001? Ms Chopping, this is a letter from Crown to the GWC dated 14 December 2020. It relates to the implementation of controls and reforms in response to issues that arose in the ILGA inquiry. You'll see in the introduction that it refers to a presentation that was given by Crown to the GWC on 27 October 2020 regarding that reform program. Now, you're familiar with this letter, aren't you?
I'm familiar with correspondence. I understand that there's been a significant amount of correspondence from Crown to the previous chair and to myself in relation to changes that are happening at Crown in personnel and in relation to steps being taken or issues that have been identified that Crown wishes for GWC to be made aware of. In terms of the detail of this particular letter, I'm familiar with the fact that Crown is writing to us on a regular basis, but I don't believe.
I'll just explain to you. There were reports that were enclosed with this letter regarding the Riverbank investments account. Those were reports prepared by Initialism and Grant Thornton. And do you recall sending an email to Ms Coonan on 16 June of this year?
Yes.
And that was in relation to this letter and those reports. Do you recall that now?
So thanking her for, or introducing myself
Yes.
and acknowledging receipt, yes.
Yes. You also had a series of questions.
These are questions from the Gaming and Wagering Commission. As I understand it, the meeting before I arrived, Ms Coonan attended via video link, and the link, there was poor quality associated with the link, but that there was the time that there was in GWC members reported to me that they felt that there was insufficient time for their questions to be answered by Ms Coonan, and that they sought to ask her a series of questions. As I understand it, at the meeting it was determined that questions could be put to her after the meeting, and that letter comprised the questions.
Okay.
So those questions were not my questions, they were questions from the GWC members.
I understand. Now, I have some questions about communications between the GWC and Crown before the letter of 14 December 2020, and I appreciate you only took up your role at the end of May this year. And so the questions that I'm going to ask you really concern information that's been provided to you by the GWC or the department. Is it your understanding that before the GWC received this letter from Crown on 14 December 2020, that Crown had disclosed to the GWC the aggregation issues relating to the Riverbank account that had been identified in the ILGA inquiry?
I do not know.
Can I have...
I don't know. I can't answer that. Yep.
Thank you. Can I have another document brought up? This one's not to go on the public screen, it's subject to a non-publication order. It's CRW.518.002.3444. So what you'll see here, Ms Chopping, is a copy of the presentation that was actually provided by Crown to the GWC on the 27th of October 2020. That is the presentation that was referred to in the introduction to that letter that I took you to at the outset. Has anyone from the department or the GWC ever shown this document to you or discussed its contents with you?
Can you show me more of the document?
Can we go, in fact, to, and I'll just direct you to the particular pages I'm interested in, page .3445. Now you'll see there that the agenda to this particular presentation included, and the first and second bullet points are the critical ones, an update on the ILGA inquiry, and also the second bullet point, a recap on immediate controls. Then can I have the document moved to page 3448? And you'll see the heading to this particular slide deals with immediate controls implemented, and it shows that Crown had mentioned the fact that through the course of the Elgar inquiry, certain shortcomings had been identified. Took them as serious issues, and then the sub-bullet points, you'll see, identifies the fact that the Riverbank and South Bank accounts had in fact been closed back in December 2019. And in particular, then you'll see the bullet point after that says that Crown has issued a direction to the cage that under no circumstances should transactions be aggregated in SICO. And there were further remarks in relation to a direction that had been implemented prohibiting cash deposits by patrons into Crown's bank accounts. Also a direction prohibiting third-party transfers. And there are other matters which I'll take you to shortly. Does that assist you in recalling whether or not this document's been shown to you?
So I don't believe I've seen this document specifically, but as I mentioned earlier, there discussions at by GWC members both at the strategic planning session held I think in my second week, and then at our initial meetings have referred to some of the elements that are contained within this document. So the matters that you refer to are not unfamiliar to me. This document itself, I do not recall seeing it, but as you will appreciate, in 12 weeks, I have there's been a lot of content that's come to me that I may not have had an opportunity to have a look at.
I understand. Can I ask you then, would you accept, but based on the contents of that slide alone, that Crown had discussed with the GWC the aggregation issue in relation to the Riverbank account and the controls that had been implemented by them to mitigate?
Your Honour, this witness was not present at the meeting where this presentation took place. If my friend wishes to make legal submissions about what a document was there, he can do that, but this witness can't answer what was discussed at a meeting she was not at.
Well, the question was whether the witness accepts that this presentation records these matters, not whether she was present.
Well, I think all
to
she can
witness
say is whether
discussions.
she interprets this page as being a discussion.
I'm content to confine the question that way. Do you accept that these are the very matters that are presented in this presentation slide, the aggregation issue that arose in the Elgar inquiry regarding the Riverbank account?
Yeah, it is a very difficult question. Like I can obviously read what's on the paper, but the degree to which this was the presentation that was provided and the degree to which it was discussed or how it was covered, I have had feedback from GWC members and from staff in relation to Crown's presentations to the GWC. The feedback that I have received has not spoken specifically about the items that are listed there. That's not to say that those items were not covered, but I can't comment.
Thank you. I'll ask for another document to be brought up then. It's CRW, and it's not on the public screens, please. CRW.706.005.0253. Now, at the bottom of the page, Ms. Chopping, you'll see it's an email from yourself to Ms. Coonan on 16 June 2021. Do you recall that email?
Yes.
And if we can go over to the next page, please, 0254. And can we just expand questions 6 and 7, please? Now, This is the email that I mentioned earlier when I took you to the 14 December 2020 letter. Can I just take you to question 6 first, where it says Crown Casino made no reference to the previously circulated reports during their presentation to the GWC. Now, pause there. In brackets there it says insert date. Should I take that to mean a reference to the presentation that occurred on 15 December 2020?
So can I say that, as I indicated previously, the questions that have been put together here were from GWC members themselves, specifically. As I wasn't in attendance, I wasn't able to draft questions in relation to the session. The email, if I recall, was drafted by Fiona Roche, who was the Deputy Director General, to be sent by me because Ms Coonan had written to me directly.
And did you discuss with Ms Roche the content of these questions and the purpose behind them?
No, because the undertaking that I gave GWC was that they should furnish us with their questions and that we would convey those questions. These are the questions that they wanted to ask at the time of the presentation, but there was insufficient time for them to be able to question Ms Coonan.
And so coming back to the date then, when you talk about the presentation, is it your understanding that that's the presentation that occurred on the, or discussion,
Yeah,
that occurred
on
on the 15th of December 2020?
I don't know. Can't answer the question.
The next sentence talks about the fact that the last minute circulation of the report, and should I take that to be a reference to the reports annexed to this 14th?
As I say, these are questions from the GWC that have been then assembled by Fiona to be sent to Ms Coonan, as if they were questions that would be verbally asked at the end of the verbal presentation provided by Ms Coonan at the May meeting.
You received a response to these questions from Ms Coonan. Do you recall that?
I don't recall the detail of the response.
Okay, I'll take you first to question 7, and I'll just invite you to read the question that appears on the
Can I just clarify that the correspondence is sent by me and the correspondence is received by my office, but it's automatically transferred to the CCO or the Secretariat function for GWC with a request for there to be a paper presented to the next GWC meeting unless the correspondence is urgent for circulation.
I understand, but ultimately this email was sent by you under your name.
Yes. Well, it was, yes, yep, from my email address, having been drafted by the Deputy Director General.
Thank you. Can we just move forward to page 0255? So the email has gone off from you in your position as Director General, correct?
Yes.
Thank you. Can we go back to the previous page? And I'll just let you, Ms Chopping, read question 7 as well. Now, can we bring up another document, please, again, just on the personal screen, it's not the public screen. It's CRW.706.005.0257. And what I'm bringing up, Ms Chopping, is the response that Ms Coonan provided to you. You'll see that that is dated 22 June 2021, specifically in response to the information requested in your email 16 June. Can I move forward, please, to page 0260? You don't recall the responses to those questions?
I recall the correspondence being received, but I don't recall the detail, no, because as I said, that, you know, on a day-to-day basis, most of the what I've asked for the executive manager of GWC to establish is an appropriate correspondence in process for dealing with GWC correspondence, because in my opinion, it's ludicrous to expect someone in this position who might receive 200, 300, 400 emails a day to make sure that GWC business is attended to as the emails come in appropriately. It needs to be acknowledged by an appropriate correspondence in process. Similarly, I think you'll be familiar with the correspondence that I sent asking Crown to not just forward lump documents to my email inbox, but rather to preface that with correspondence covering it, indicating what the intention was in forwarding the information. So setting up an appropriate correspondence in and out process is a key function of the GWC Executive Manager.
I understand. Now, you were writing to the Executive Chairman of Crown Resorts Limited. Did you consider this an important piece of correspondence?
Yes.
I'll then direct your attention, please, to what is the combined answer that's given to questions 6 and 7, where it said that Crown's provision of the reports to the Commission in a letter dated 14 December was not intended to align with the meeting the following day. And they'd given the volume of materials in the letter, Crown envisaged that the Commission would consider them after the meeting and raise any queries with the relevant individuals. Now, did you convey this letter to either other members of the GWC or the department?
Yes. Well, yes, I did. I mean, yeah, I did. Well, I believe I did. But as I just indicated, I'm not the only person that controls the flow of incoming correspondence into my inbox. Obviously, my executive support officer forwards correspondence to the relevant place. And I have asked for an appropriate correspondence in process to be established so that it's not reliant on me providing the secretarial service for the GWC.
Appreciate that, thank you.
So to the best of my knowledge, that has happened.
Have you had any discussions personally with anyone within the GWC or the department about the contents of that letter, in particular the response to questions 6 and 7?
I have asked for all correspondence to Crown to be presented to GWC with covering information in terms of analysis.
But specifically this letter?
I cannot recall that. And indeed, you know, as you can appreciate, setting up an incoming correspondence process so that I'm not the person who's responsible for the secretarial service for GWC has been an important measure taken. So if that hasn't occurred, then it's an oversight.
Thank you. Now, should I understand you've had the opportunity to read the questions that have been drafted for you and the response you received from Crown? Do I understand from the communications then that the criticism that had been raised by the GWC was that the reports that were provided on 14 December were provided late in the evening with insufficient time for the material to be considered for the meeting the following day?
I believe that is what their concern was.
And Ms Coonan's explanation, as you've seen in this response, is the reports provided on 14 December were not intended to align with that meeting, and Crown expected that upon review of that material, any queries would be raised with Crown.
I think it's fair to say, well, GWC members have expressed a significant level of frustration in relation to what Crown have presented to them or told them over more recent months. So it doesn't surprise me that they were upset about the timing of what they perceived as being insufficient time for them to get to grips with the content. that's one of a number of pieces of feedback that they've got about the information that's been given to them by Crown.
I understand, I appreciate that. Can we now move back to the letter of 14 December, please? It's GWC.0004.0015.0001. Just as that's coming up, Mr. Chopping, so you'll recall that that letter was, of course, preceded by the presentation on 27 October. I just want to take you to some of the particular aspects of this letter. So I've previously identified for you the fact that the presentation of 27 October is referenced in the introduction. Further down on that same page in the second paragraph, you'll see that Crown notes the fact that they were grateful for the Commission previously providing Crown with an opportunity to address issues that have been identified through the course of the ILGA inquiry. And in particular, the second bullet point that appears there, the controls that the Crown Board and Crown Management have implemented in response to the ILGA inquiry. Can we just scroll through to the second page and then onto the third page? So you'll see that the letter itself essentially ends at page 2, and then page 3 commences with an annexure. Can we just go directly to page 3, please, and remove 2? And the heading to the annexure is ILGA inquiry, and you'll see the second heading refers to immediate controls. I'll just direct your attention to each of the paragraphs there. As foreshadowed in the presentation to the Commission, certain key issues have been identified through the course of ILGA. Paragraph A, once again, identifies that the Riverbank account was closed in December 2019. Paragraph B identifies the fact that Crown has issued a direction to the Cage that under no circumstances should transactions be aggregated in SICO. Are you familiar with the aggregation issue, Ms. Chopping?
No. Well, not in sufficient detail to be able to discuss it or speak to it with any. It's a bit like the EGM's issue. I'm not sufficiently briefed in terms of the detail because of the circumstances that I've found myself in terms of starting in this position. There's been immediate issues around staffing, around conflicts of interest, around our regulatory approach that have needed to be attended to. So we're starting with those, the remediation issues, and then moving on to training, development, familiarisation with the background. So not as familiar as I would like to be with the issue.
Did anyone from the GWC or the department brief you at any stage in relation to the aggregation issues and the Riverbank account?
There was reference to the accounts in a verbal handover that I had with Mr. Ord prior to my commencement.
And what was the substance of that discussion?
He provided some background to me as to the context of the current situation for the Royal Commission arising, and made some statements about what he perceived to be historically the role of GWC with regard to anti-money laundering issues, and then referred to these accounts.
And what did he tell you in relation to the accounts?
That there were issues that had subsequently come to light, that where it appeared that there would be cause for concern for in relation to Crown's conduct.
anything more specific than just issues and Crown's conduct?
It was a long discussion that covered a whole range of different issues, but nothing more specific at this, that would help with this discussion.
Did he explain anything in relation to steps that Crown was undertaking to mitigate against risks of aggregation?
No.
I'll take you back to the letter. You'll see in paragraph B that Crown specifically refers to the fact that they've implemented, or at least provided and implemented, a bank statement monitoring policy, which they provided as attachment 1. Then in paragraph C on that same page, Crown explains that it had given a direction prohibiting all cash deposits into Crown's bank accounts, which was then enclosed as attachment 2. And go to the next page, please, page 4. You'll see then in subparagraph D, reference to the implementation of a policy prohibiting third-party transfers. That policy was enclosed again as attachment 3. Then if you make your way down, halfway down the page or thereabouts, the paragraph beginning importantly in respect of the controls referred to in paragraphs A to E above. I've taken you to 4 of them, A to D. Crown confirms that as committed during the presentation to the Commission, Crown has submitted proposed amendments to the casino manual operations. And then the next paragraph after that, you'll see it then goes on to say, we further note that in respect of the issues identified during the Elgar inquiry relating to the Riverbank account, we separately enclose as attachment 4 the Grant Thornton and the Initialism reports, which were the very matters the subject of your email of 16 June, you recall that. By page 4 of this letter, Crown has set out at some length the issue, the policies and directions, and provided the reports in the context where the issue regarding aggregation had at least been flagged as early as the 27 October presentation that I've taken you to. So what I want to understand, based on information that's been provided to you in your current position, between the receipt of that letter of 14 December 2020 and your email of 16 June 2020, to your knowledge, should the department or the GWC reviewed either those policies and directions or the reports from Initialism and Grant Thornton?
I'm not in a position to answer that question. So can I say that in the 3 meetings that I've chaired of GWC, the matters discussed in relation to Crown have been have not been in relation to Crown's remediation. They've been in relation to ongoing concerns and new information that's come to light in relation to new investigations that are underway in relation to Crown's conduct. So that has occupied a significant amount of time, not a detailed understanding of this aspect of remediation. And in terms of who worked on it between October and May the 31st, I'm not familiar with that. But I would assume that it would have been the Chief Casino Officer at the time, but I can't answer that question.
Do you know if the GWC or the department has raised any queries with Crown about the substantive content of those reports at any time since 14 December 2020?
I don't know, but as I just said, there's been a period of restabilisation, and there's also been some new matters on foot that are now the focus of our investigative work.
And along the same lines, have you seen any agenda items in meetings that you've attended concerning the subject matter of those reports?
I do recall that there has been discussion, as I said before, there's been discussion of those accounts at GWC meetings. It's not necessarily been discussion led by agenda papers, it's been discussion by members, possibly in the context of debriefing their review of subsequent media articles or information that's come to light through this inquiry or the Victorian Commission. But in terms of, I have asked for the department to develop analysis of Crown's remediation response to date and the new updated information that's been provided most recently by Crown. That's yet to occur in a fulsome way.
Thank you. And just the last question. In your witness statement, paragraph 51, that were taken to it by Mr. Lee, you explained that as to whether the GWC intends in the future to make use of any services, the GWC recently resolved to support the department commencing a procurement process to employ the services of external experts in anti-money laundering and counter-terrorism financing, and their brief will be to undertake an annual audit of Crown Perth's bank accounts, review the casino manual operations to ensure all aspects of AML CTF are captured in it, and develop an audit program based on the internal controls. When you prepared your statement and made those remarks in paragraph 51, had anyone briefed you at length in relation to these issues regarding the Riverbank accounts, anti-money laundering, or controls that should be in place?
A lot of people have had a lot to say to me about anti-money laundering and the information that's in the public domain that's been raised through both commissions. As I mentioned, Mr. Ord provided me with information verbally during the transition period, and indeed in my early period of commencement, I asked questions about what was currently being done in relation to AML and what the plan would be for the future. In terms of an investigation into either of those accounts and the findings of any investigation, I haven't had that level of detail of briefing. But I can say that from the concerns that have been raised, there's definitely GWC is keen, as am I, to ensure that there is an examination of all of the matters contained in item 51. And I think I mentioned in my evidence previously today that the relationship between the regulated entity and the regulator has gone from one of being quite what appears to be a very trusting relationship, to one that is much less trusting now than it once was.
I'm sorry, go on.
No, that's fine. I'll leave it there.
Thank you. As you sit here today, but you're not aware whether within the department or the GWC anyone has done a review or analysis of those policies and directions that I took you to, or the initialism or Grant-Thornton reports?
So the GWC has not received a fulsome report during my time as chair. Whether or not that is being worked on within the department or has been worked on within the department, and I just haven't been appraised of that, I don't know.
Thank you.
So I'm not saying it hasn't happened, or that it isn't currently underway, but it hasn't been discussed at GWC, hasn't been presented to GWC in a manner that GWC would find fulsome
Thank you. No further questions.
as yet.
Thank you, Commissioners.
Thank you, Mr Garros. Anyone else?
Just a couple. Mr. Chopping, thank you. In talking about the restructure, you talked about separating out gaming and wagering inspectors from liquor inspectors. One of the issues we've spent some time on is trying to identify the level of resources within the department that are actually devoted to GWC activities. So I take it as part of this restructure arrangement, you'd be looking to get better financial advice out of, so they should be able to get a better understanding of the resources going.
That is exactly right. So as recently as Friday, I made it clear to the CFO that she, it was clear by the fact that she was in attendance on Friday, and my intention from the beginning was for the CFO to be in attendance at every meeting. In my second week, I believe it was, I asked for information to be given to me about the inputs and outputs in relation to how the finances work for GWC, including the accountability mechanisms that are in place for recording time and the nature of the work that's done. The paper that you saw on here yesterday was the result of the first step of that work. What I asked for and what's been agreed to on Friday was for a detailed forward budget to be provided for the September meeting for the GWC to settle, and that we commence a mechanism of time recording, and also time recording where, so we discussed this at GWC on Friday, time recording where you can actually tell the difference between what I think someone compared it to a tonsillectomy versus a hip replacement. So, it's not horses for courses. Where I come from, we have a mechanism for time recording of against different legislative instruments and then different activities. And so, it'll be an emerging project, but definitely in terms of accountability to the GWC about what costs what, that's an important part of them being able to have the accountability reassurance, but also the planning, in terms of planning. So when they know how many is it worthwhile doing this many inspections here, or how much of your budget is that going to consume, versus actually you'll get better value for money if you're focused in these areas here.
Very good. All right, thanks very much for that. On a separate issue, gambling related harm, you talked about financial counsellors and that you had some experience in that area and some feedback that the level of people with issues around problem gambling was fairly low. Do you want to just refresh?
So as I understand it from the information that's been received by the department, financial counselling services must be asking a question in relation to or making a normative assumption from the information provided by the client as to whether or not problem gambling is a driver for their attendance at financial counselling. The figure that's reported was 0.8%.
Okay.
Now, in my experience, I would have thought it would have been significantly higher than that. But perhaps it's the collection method that means that it's underrepresented. So we need to get some better discussion with communities about recording information.
Okay, thank you very much. That's all from me, Commissioner.
Thank you. I have two areas I wanted to ask you about, Ms. Chopping. The first is in respect of harm minimisation. Do you have an opinion as to whether it's appropriate to seek funding for harm minimisation programs from the casino itself?
Yes, I do have an opinion. There's been, it's only the opinion that I've formed in terms of my experience with creating a charging regime for regulated entities in the utilities industry and in other industries. So I think it's entirely appropriate for a levy to be placed upon regulated entities to fund work that's being done. I don't agree with the current arrangement where the regulated entity or others would be participating in the policy development associated with procurement or the work done in that space. So I think there's more work to be done to look at the membership of the boards and committees associated. But I think industry, my personal opinion is that there's a method by which industry can contribute funds for those purposes without there being a capture issue or any kind of, Dracula in charge of the blood bank assertions.
So my second question was about then what about the regulated being on the Problem Gambling Support Services Committee? Do I understand from your answer then you're not quite so positive about that aspect of it?
I think there's a time and a place for the regulator and indeed the state and NGOs to have interface with the regulated entity to provide feedback and information. I don't believe there's a place for the regulated entity, unless requested information by that group, to be addressing the very problem that arguably they are the creator of or the facilitator of.
Thank you for that. And the second area I wanted to ask you about was the regulatory framework. You gave an answer about the chief casino officer and that they are appointed by and report essentially to the Director General or the departmental managers. Is that
yes,
your understanding?
Appointed under the Public Sector Management Act and reporting to whoever their next line up is in the department, and ultimately reporting to the through to the Director General. Yes.
So what I want to ask you is that if GWC does not sort of direct or directly supervise the departmental officers who are the officers performing the acts by which its functions and responsibilities are discharged, how does the GWC ensure that its statutory functions and responsibilities are being discharged?
And that, I think, is very much the heart of the issue that we're addressing at the moment, through ensuring that we've got a very good, clear governance system in place, that we've got roles and responsibilities, we've got an agreement about what will be provided and what won't be provided. There's accountability that surrounds that. There's independent verification of that. So I think there's a whole range of measures that we can take that that can assure us as GWC, so speaking as the chair, that can assure us that we're getting the appropriate service delivery that we are expecting, without the need to necessarily employ staff directly ourselves or manage them directly ourselves or employ consultants directly. But I acknowledge that there is an opportunity under the Gaming and Wagering Commission legislation with the Minister's approval, for GWC to indeed employ staff directly or consultants directly, and that may well be where the GWC ultimately decides to go. And the Minister may well approve that. And I discussed that with the GWC members in terms of the difference between the department procuring consultancy services to deliver then the service to GWC versus GWC employing consultancy services directly after they've sought approval from the Minister. So there's a range of different models that we could look at going forward. At first, we're just trying to stabilise the current environment and make what we've currently got actually function effectively and efficiently, and address the legacy issues that we've got in terms of the regulatory approach taken by the department.
So do you think those different options can be implemented under the current statutory framework, or do you think that there needs change to the statutory framework to enable the GWC to choose which option, or one of the options you've discussed?
So of those two options, I think the statutory arrangement enables GWC at the moment to employ consultants or to employ staff directly upon approval from the Minister. And that there's no requirement, there's no change of law required for that to occur.
What about I hear what you're saying in respect of that. What about the chief casino officer?
If they wanted to if they decided that they would wish to have the chief casino officer functions performed by someone who is employed as a private in the private outside of government, then they could propose that to the minister, and then there would be the minister could consider that under the current legislation, as I understand it, and the benefits or otherwise of doing that. My personal opinion is that structural change will give you has some potential to be able to make some positive changes, but more importantly, it's about the leadership within the GWC board in terms of its. I don't think that the current legislative framework is such an impediment to actually making something much better than what we've currently got, and we're definitely on that journey.
Thank you, Ms Chopping. Those were the two areas I wanted to ask you about. Is there anything arising from that, Mr Lee, before I ask Ms Seawood?
No, thank you, Commissioner.
Thank you. Yes, Ms Seawood.
The questions.
Thank you, Ms Chopping, for your assistance today. Can I explain to you what happens from now on? The summons which you've received will remain in place in case Commissioner Owen, who is not here but will refer to your evidence in case he wants to ask you some questions, and also if after reflection we have some further questions for you. But otherwise you're certainly free to go now with that, and we will let you know if we do require any further assistance. So thank you very much.
Thank
and we
you.
will now adjourn until Tuesday.
All right.